Council. Ms. Winfrey, good morning.
Good morning, Judge.
All right, we've got a couple of motions ready to go here this morning. We'll note that we are live streaming on YouTube. I am working remotely today, so the courtroom is not open. So we are making the hearing public through YouTube. I think we've got a lot to do on the Liatis Southwire Company case, so I think I'm going to save that one for second. And we'll start with the Wasserman Group.
Thank you, Your Honor.
All right, and
Thank you.
I think we have, this is defendant's motion to dismiss, so you can go ahead when ready.
All right. Thank you, Your Honor. My name is Scott Ratchick, and I represent the defendants in the case. The case is really fairly straightforward. I think it is a motion to dismiss.
Counsel, please excuse me. As soon as the judge got on, I got dropped. And so I'm now getting back in. I mean, as soon as he said hello, I got dropped and I'm just coming back in. I heard him say, this is the defendant's motion. So would you mind starting over just from the top, and I'm ready.
I would be happy to. And I heard some shriek. I wasn't sure. I will happily start over. Good morning, Your Honor. Excuse me. My name is Scott Ratchick, and I am counsel for the defendants in this case, David Andres Weaver and Christina Weaver Vest, who are trustees of a trust. The trust owned property that was being sold. The trust entered into a purchase and sale agreement with an entity called U.S. Property Holdings. That contract was entered into on or about May 7th of 2019. That contract provided for certain purchase terms. It was extended a number of times through amendments, and then, as we contend, it was ultimately terminated. Excuse me. The contract to which the purchase and sale agreement that we're talking about, the Wasserman Group was never a party to it. They were recognized as having an interest to be paid a commission, but they were only to be paid a commission under very, very specific terms. And that is notably in section 11 of the purchase and sale agreement. It specifically said, no commission shall be payable unless the transaction contemplated by this contract actually closes, even if the failure to close is on account of a default by seller or purchaser hereunder. The contract never closed. So, and the transaction never closed. That alone should negate their claim for a breach of contract, which is predicated upon a claim under the purchase and sale agreement.
But obviously, there was some agreement for something, even if it wasn't directly reflected in the purchase and sale agreement. A broker is not going to go through the effort of procuring a purchaser without some expectation of payment. So certainly there was some discussion somewhere about whether it's reflected in a written contract or not about the circumstances under which they would be paid for their efforts.
Well, I understand your comments, Your Honor, and let's a little bit more into context in that regard in particular. The Wasserman Group is owned by the same people who bought the company or bought the property.
I did notice that. I thought that was interesting.
It's not a lost fact. The Wasserman Group is also owned by this same metaphysical charity organization that's out there that I'm not sure what that's all about. I do have suspicion, but it's not relevant to today's proceedings. And you know, I will get back to the legal argument, but let me stay focused on your question. In the transaction that ultimately did close, again, not between the buyer and seller under the purchase and sale agreement, but between the trust and this AHA Paulding entity, that transaction ultimately closed. There were payments made under the purchase and sale agreement, earnest money payments that were non-refundable to the USPH buyer under the PSA. The trust had no obligation to return those funds to USPH or to anybody else because it was earnest money that they lost by not closing. It got credited to some extent in the transaction that did close, and that's where the Wasserman Group got paid. All right, so call it however you want to slice it and dice it. It's between, and I don't pretend to know yet what the negotiations are between the Wasserman Group, AHA Paulding, US Property Holdings, because they really created this AHA Paulding the day of or the day before they ultimately closed the transaction. So, but it says within the closing documents that that earnest money, which did not have to be returned, was going to be applied to the ultimate transaction. It also says in the closing documents for this transaction that did ultimately close, the Wasserman Group specifically acknowledged that they had been paid what they needed. It says in the closing documents, and this is a note to the closing documents signed by the Wasserman Group, that the undersigned broker hereby waives all lien rights against the property arising under any law and acknowledges payment in full of all commissions and fees due to or arising out of or relating to the property as of the closing. Right? Now, the Wasserman Group.
Didn't they try to add some qualifying language? I mean, I think that was as of the closing date was handwritten in there. It seemed like that's some effort to avoid the absolute finality of a request for payment. Why add that language if the rest of it, if it means the same thing, whether they add it or not?
Well, let me ask you this instead, because I understand your question, but I think a better question is, if you are if you are owed money that you haven't been paid, why would you have this note in the closing documents anyway? Why would you acknowledge payment if you're saying that you've never been paid? I personally think this handwriting is in there to show that as of closing, everything that's owed or due to be paid is done, right?
Was everything done then, though? Were there other tasks to be performed after the date the closing document was signed? Were there other sort of conditions subsequent or other things that had to happen?
Nothing other than the payment of the note, the promissory note by AHA Paulding. That was it. That was their mortgage, right? So there was nothing left to be done.
And how long what was the time frame for payment of the promissory note? Was it like a mortgage that it was 15 years or 10 years or 30 years, or was this a much shorter period of time?
It was shorter. It could extend to 18 months. All right.
So, what I'm getting, at least, I don't know if it's explicit, or at least my recollection from the papers is that, well, the commission wasn't going to be due. Our agreement was the commission wasn't going to be due until the note was paid, and that was a fairly constrained period of time. I don't see any evidence of any written agreement there, but I don't see any evidence that there wasn't such an agreement there.
Well, but I guess I keep wondering, and you're right. By the way, the Wasserman Group and Mr. Levy's firm is the one who did the closing on this. All right. So, and they were the only counsel of record involved. They prepared all of the paperwork. They did it. They represented the Wasserman Group. They represented the buyer and all of that. Why would you have a note saying I waive and acknowledge receipt of all payments, all commissions as of closing? If it's not payable until later, that's what you say, right? Or you put into writing somewhere, subject to payment later. You don't say POC, paid out of closing, right? If you haven't been paid, you don't sign anything like this. And I think the fact that there is a written acknowledgement saying that we have been paid as of closing, right, it is fatal to them, because one, we do recognize that somebody got credit for $85,000 that they weren't entitled to, whether it's the buyer or the Wasserman Group. And again, they are one and the same, effectively. They got this money that they weren't entitled to, and they said, we've been paid. So under that theory and those words, I think that they cannot prove breach of contract. They also can't prove breach of contract because they're relying upon the purchase and sale agreement, that PSA. And that PSA was terminated. That transaction never closed. So they, for all those reasons, there was no assignment here. There was nothing. The closing documents don't even reference the PSA. It is just another transaction under completely different terms with somebody else that the buyer, that stepped in to buy this property. And I think that I've said what I wanted to say about that language about 1231. But I did want to, and I had a note here that I was seeing, if it were to have said, we've been paid everything that we're due as of 1231, it would have said that, but it didn't. It said, we've been paid everything that we're due for the property as of the closing. So that to me says we've been paid as of this closing, we've been paid everything that is due to us for the closing of this transaction on the property. That to me is exactly what the words provide. It was written by a lawyer. If he wanted to say something different, they could have said something different. And they would have otherwise not have put that in here, period. It makes no sense to be here. It's an unnecessary document otherwise. And it would have, said, we are to be paid, when the promissory note is due. If they can't prove something other than that, and they certainly haven't alleged anything other than that, I think that their claim fails. I think it also fails on the claim of quantum merit because for a couple reasons. One, they've acknowledged in writing, there is a writing related to this. And they've acknowledged in the writing that they received whatever commissions were due to them. If there is a written agreement, or if there is a written statement as to the promises involved, you cannot have a claim for quantum merit. I mean, that's black letter law. Is only when the parties do not expressly agree that the law interposes and raises a promise, and no agreement can be implied where there is an express one existing. That's classic Restoration Inc. versus Bean. It's also Tolson Firm LLC versus Sistrunk, which we cited to both of those in our papers. But because there are written instruments governing what's going to happen relative to this transaction for the sale of the property, and the Wasserman Group is involved with those papers, you can't have a quantum merit. I'm happy to answer any other questions for you.
No other questions for you, Mr. Ratchett? All right, let's hear from Mr. Levy.
Thank you, Your Honor. First of all, as Your Honor said, this is a motion to dismiss. So the standards that we're talking about is simply looking at the pleadings. And those pleadings also have to be construed in our favor and to do justice. And so in this case, what we've alleged is that the trustees as sellers sold land to a buyer in exchange for a promissory note, and that the trustees agreed to pay the Wasserman Group a commission when the buyer paid off the promissory note. We allege the buyer paid off the promissory note, but yet the trust has failed to pay the commission. That's a breach of contract claim. Now, I can go into some of the arguments that have been made, and one is this idea that, first of all, they take an interesting position. It's either one, the contract was terminated, so therefore we don't owe a commission. At the same time, they say, but we also paid the commission. So if anybody's trying to have it both ways, we believe it's them. But if you look at the documents that are attached here, you can see that there were two brokers, each of which under the PSA were not to be paid unless there was a closing. Now, it's undenied that, in fact, the listing broker was paid. We allege we haven't. Now, it's the same transaction, so they can't have it both ways on that. Then, in terms of that language, the as of, that to us is exactly because of the contingency. That was payment to be due when the promissory note was paid. So as of the closing, there was no money due, but it preserved it. Because if you look in the same documents, when it refers to the other broker, all the language, the same language is there, except for the handwritten addition. That handwritten addition has to mean something. And by the way, it was my prior firm, not this current firm, but in any event, we can get into all of what that means, but not at the pleading stage. At the pleading stage, we have satisfied our burden to show, in fact, that we don't even have to have all the elements of the contract, but we have pled sufficiently the facts here, and it is the defendant's burden to prove that there is no set of facts under which we can recover. We say that you can't do that, and certainly looking at the documents here where the documents at closing acknowledged the Wasserman Group and the other broker were the only brokers that were involved and the only ones entitled to a commission. So that is continuing to preserve. It shows there was an obligation. And as far as the meaning of POC, paid out of closing, payable outside of closing, all that is yet to be developed. But the allegations, essential allegations are, we were due a commission when the purchaser paid off the note, and that condition was satisfied afterwards. Again, there will be time to go outside of the pleadings and explain what all, how this came about, but for the pleading purposes, that was sufficient. Then in terms of the quantum merit, and one of the very cases that the defendants cited in their brief, the one Bluff Drive, talked about how it was a one count complaint that had both contractual and quantum merit elements into it. They were both allowed to go to a jury, and the verdict was sustained. There's the concept of, one, you don't have to make that election because we've pled in the alternative. You don't have to make that election until you get to down to the verdict and the judgment. Also, of course, even if you have an express contract, if you go beyond that, if there are additional services are provided, then you can get into quantum merit. But here too, when they're making the argument that the initial agreement was canceled, so that in fact there was no operative agreement, and we say we still provided a service by having this other buyer come in, then that's also sufficient for quantum merit. So clearly at the pleading stage, we believe we have satisfied what we need to in terms of defending against the motion to dismiss. I can go into more, Judge, but that's really the essential elements of it. I think you seem to have a pretty good grasp already of what we allege. So I'll stop there.
All right, thank you, Mr. Levy. Anything in particular you want to respond to, Mr. Ratchet, before I go ahead and give you my ruling on this?
The only thing I would say, Your Honor, is if there was an agreement for some commission to be paid when the promissory note was paid, they have not introduced or asserted there was an agreement for that. We haven't seen it. It doesn't exist. They have not introduced it, alleged it. And to the contrary, there is an express writing that refutes that. Thank you, Your Honor.
All right. So at the motion to dismiss stage, my task is to search through the pleadings and relevant attachments, if any, to the pleadings, determine if I can find a cognizable claim. And while I hear you, Mr. Ratchet, with respect to the PSA, I don't necessarily see a breach of contract claim there, but what Mr. Levy has outlined, and from what I gathered from reading the papers, there is a claim fairly presented here that there was an agreement to pay commissions to the Wasserman Group on that second transaction, and that those commissions would only be due once the note was paid. And I think, as I understand the limited amount of closings that I've either been through or seen on paper, usually the money gets delivered at the closing and everybody gets paid out of the proceeds at the closing. So there isn't a reasonable construction that you can place on the document that because no money changed hands that day, no money could change hands to the broker.
I'm sorry, Your Honor. Money did change hands that day. Plenty of money, more than enough to cover the brokerage fee.
All right. I stand corrected on that part, but there was still money to be paid.
Like every mortgage.
And in a much shorter time frame, where perhaps the broker was, had fewer concerns about, not seeing that money for 15 or 20 years. I don't know. All of those are fact issues for discovery, whether there was such an agreement, what the terms were of the agreement, who made the agreement and on whose behalf, what folks' understanding was, and whether it was reasonable. Those are all questions of fact that can't be resolved here. But at the very least, what we've got is the allegation of an agreement, and if proven true, enforceable. And I believe that once you've got that, you've got the ability to plead in the alternative that even if you can't prove an enforceable agreement, you can still prove that, well, I made efforts in some reasonable reliance that I was going to get paid for my efforts, and you took the benefit of those efforts, and I'm due something for those efforts. And I think that's the essence of a quantum Merowith claim. I think that claim is squarely presented in the pleadings. So the motion to dismiss is denied.
Thank you, Your Honor.
All right, Mr. Levy, if you would, please prepare an order.
Yes, Your
Proposed order, run that by Mr. Ratchix and send that to Mr. Townsend, and we'll go ahead and get that entered.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you both. You are excused.
Thank you.
All right, let's talk now about, and let me make sure I get the pronunciation right. Is it Liadis?
That's right, Your Honor.
All right, Liadis versus Southwire Company, and we've got a few motions to handle. I ask in a hopeful sense, but not not with any expectation. Have any of these motions become moot or been resolved? I've got the motion to strike experts or alternatively for reasonable fees and expenses. I've got the motion to set a reasonable fee for Mr. Provder. I've got the motion to exclude testimony of Marshall, motion to exclude testimony of Wogalter, defendant's motion for summary judgment, and plaintiff's motions for partial summary judgment. Are all of those still live and need to be heard?
Your Honor, this is Stephen Nauman from the plaintiff. We filed a supplement to our response to the Dr. Wogalter Daubert motion. We suggest that that motion is moot, given that defendants have taken Dr. Wogalter's deposition. Defense counsel might disagree with me, but that's our position.
Yes, unfortunately, Your Honor, defense counsel does disagree. I think Mr. Wogalter's deposition raised more questions than it did answers. And we are prepared to argue that motion today. Unfortunately, by the court's notice, it was defendants' understanding that only the Daubert motions, so the motion to exclude Mr. Wogalter and Mr. Marshall, as well as the summary judgment motions, were up for today. The motion to set a reasonable fee is still outstanding, as is the motion to strike plaintiff's expert testimony for sanctions, but we did not understand that those motions were being heard today.
As I understood, it was just, as I understood the motion, it was the notice, it was a hearing on various motions. So I just want to make sure that everybody is prepared to argue all the motions that we currently have outstanding and fully briefed. So let's just go through them. Let's just go through them one at a time. There are a number of them, and we'll see where we get.
Thank you, Your Honor. And not to be, cute with the court, we do understand that if you find in defendant's favor on the motion for summary judgment, then all the remaining motions are moot.
See, you say that with not with expectation, like I asked my first question, but with hope that perhaps
that's correct, Your
turn
Honor.
out this way.
And we may start, if it pleases Your Honor, we can start there. I think that's a rational place to begin, because I think several of the motions dovetail off of that, certainly the two Daubert motions. But I defer to the court.
All right. There's an order I have, and I just want to be clear as to whether we can hear these today or not. The motion to set a reasonable rate for Mr. Provder. Are we ready to talk about that today?
Plaintiff is.
I'm unfortunately, Your Honor, I'm not prepared to talk about that today. I prepared for the two Daubert motions and the motions for summary judgment.
All right. Has Mr. Provder's deposition been taken?
Yes, Your Honor.
Was there a rate paid?
I don't believe he has been paid at all. but I can double check. Not being paid for his deposition. Obviously, he's been paid for other work as it relates to this case.
All right. All right, well, let me just say this, and I know defense counsel's not able to, is not able to argue it, but I will say that I think there have been a number of instances in this case where early and thorough communication between counsel could have saved a lot of trouble in this case. And I say that to both sides. The invoice that I see in the discussion of the fees that Mr. Pravda wanted before the deposition even took place is beyond anything that I have seen in my practice, either as a lawyer or as a judge. He's entitled to compensation. The compensation should be reasonable. It seemed like a shakedown to me. That's what it looked like from the evidence that I saw. And
Your Honor,
I hear you when you
just-
say, Mr. Nauman, that that's his decision, but I find it hard to believe that he's charging that kind of rate to you.
He is, Your Honor. I will candidly represent to you that that is the rate I am paying for his work. I wish it
You
weren't
must
so.
be the most amazing expert, and you cannot have any other expert for this type of case in order to pay that rate. But
He is very expensive. I concede that, and I'm sure you've gleaned from my response that it's not our position, it's his position.
so he's entitled to compensation. It's going to be $250 an hour. And
Understood.
so and that's what defendant asked for it to be set. I think that's far more reasonable than what Mr. Pravda was asking for. So I'm going to grant that motion to set a reasonable fee and direct that defendants pay that forthwith to Mr. Pravda for his time, that however number of hours was taken. All right.
And just so we can wrap that up, to Stephen, if you can just issue us an amended invoice, we'll get it paid.
Sure.
All right. So that will take care of at least that one. And I thought that was one that I could dispatch quickly and early. All right. So we have left defendant's motion for summary judgment, defendant's motion to exclude experts, and plaintiff's motions for partial summary judgment. We're already on those?
Yes, Your Honor.
Yes, sir.
All right. So Mr. DeBartolo, whichever one you want to start with first. You want to start with this motion for summary judgment?
I think that makes sense, Your Honor. If you are willing to hear that first, I'll begin there.
Yeah, let's go ahead with that one.
Thank you, Your Honor. My name is James DeBartolo. I represent all defendants in this matter. Defendants move for complete summary judgment in this matter. And in doing so, defendants simply ask the court to take plaintiff's expert and himself at their word. If you do so, Your Honor, the result is a summary dismissal of all claims. With respect to plaintiff's design and manufacturing claims, plaintiff's materials expert ran extensive testing on the chemical properties and the mechanical properties of the drill bit in question here and found that no defect exists. We only ask that the court take their expert at his word and agree and find summary and enter summary judgment in defendant's favor on their design defect and manufacturing defect.
So I have to stop you right at the outset. Is that his testimony that no defect exists? I thought his testimony was that he was not testifying that a defect existed.
With respect specifically to the manufacturing defect claim, he unequivocally testified that no manufacturing defect exists. With respect to the design defect claim, he said he inspected the product and did not find a design defect. He did not look in detail at the design defect because he said that was outside his scope of his retainer, but in sum and substance, Your Honor, he did testify that he found no design or manufacturing defect.
So it's hard for me at looking at his testimony. I did look at a good bit of his testimony's report. It seems to me that reading his testimony as a whole, he's testifying that he couldn't find any problem with the design, but there seemed to be some issue with this particular product that suggested that it wasn't fulfilling, that it did not fulfill or meet the design specifications. That suggests to me a manufacturing defect, even if it's not said directly.
Well, plaintiff's expert did not testify that it deviated from any design or any of the manufacturer's designs or the manufacturer's specifications. He did not make that testimony. What plaintiff argues constitutes their design or manufacturing defect claim is a quality assurance document that according to plaintiffs, they are arguing that says that the drill bit should be able to sustain bending up to 90 degrees, and that because plaintiff himself testified that he never exceeded 90 degrees, in fact, he testified that his use was more accurately at 30 degrees, that the fact that it failed under those circumstances indicates a manufacturing defect. That line of logic is flawed for several reasons. First, the quality assurance document does not have to do with a fracture test. That quality assurance test deals with what's called springback. And it says that on the plain face of the document. And what springback is when they test that when the drill bit is bent to 90 degrees, they want it to come back to straight. So that's not a test that deals with fractures at all. All that test deals with is once it's bent at 90 degrees, how close back to straight will it revert back? So that has nothing to do with the facts of the case here, especially where plaintiff's expert, Mr. Marshall, tested these drill bits up to 180 degrees and found that none of them fractured under those circumstances. So what we have here is their expert testifying that it's chemically the same as all of these exemplars. It's mechanically the same as all these exemplars. We've tested it beyond we've tested these exemplars beyond the scope of what plaintiffs allege is the applicable test and found none of them have fractured under those circumstances. So even taking plaintiffs' misreading of the quality analysis document, we still have no evidence of a defect.
But there's no question that it's intended to be used at up to a 90-degree angle.
From that document itself, Your Honor, I don't believe that that's a necessary conclusion.
But a possible read, not necessary, but possible.
It is possible, but we have no evidence of the record in that. And plaintiffs did not take any depositions of any of defendants' principals or any of their experts. So plaintiffs thought that that document alone, on the face of the document, left enough proof to overcome their experts' finding that no defect exists. And it's important to note, Your Honor, that their expert also reviewed the documents upon which plaintiff relies for that conclusion. So it may not be included in his reporting, but he reviewed that document and still found that no manufacturing defect exists. So if that answers your question, Your Honor, I'll revert back to, would you like me to stick with the manufacturing and design defect claims while we're on the topic, and I'll move to the warning defect afterwards?
Yes.
Okay. So in opposition, we've talked about some of this already, so I'll try and be more concise, but in opposition to defendant's argument that plaintiff's expert testimony alone warrants summary dismissal, plaintiffs argue that this quality assurance document creates enough issues of fact to defeat summary judgment. Well, first, as we've already discussed, plaintiff's expert reviewed that document and found that no manufacturing defect exists. Second, they misinterpret the import of the test. It's a springback test, not a fracture test. Third, the test doesn't really have any relevance to the facts at issue here because it's a test that deals with an 180-degree bend, whereas here, plaintiff testified that, and it withstood the 180-degree bend, whereas here, plaintiff testified that he never bent it more than 30 degrees. So there is a huge disparity there. Presumably, there is much less torque and much less tension and stored energy under 30 degrees. Mr. Marshall never goes into that because he never tested it under a 30-degree bend. But it's illogical to assume that the drill bit at issue here bent at 30 degrees and having the same exact chemical and mechanical characteristics as the exemplars tested at 180 degrees would not withstand that kind of pressure. Fourth, plaintiff must rely on an expert to prove that this particular drill bit and the system that it makes up with the drill was defective. Under New Jersey case law, this is what's called a complex instrumentality. And we discussed this in the context of the Murlack case and the Louder case cited in our briefing. And where a defect claim involves a complex instrumentality, a plaintiff must come forward with expert testimony explaining what was the defect, what caused the defect, how that defect caused the alleged injury. And we have, without Mr. Marshall, none of that testimony exists. And even with Mr. Marshall, he doesn't discuss that. He doesn't talk about what was, well, he found that nothing was wrong with the chemical or mechanical composition of the drill bit itself. And he doesn't discuss how this fracture, he doesn't discuss how the fracture occurred. And we have no evidence on that issue. Plaintiff testified that he passed out prior to the fracture. So we don't know what circumstances of torque, of tension, how he was manipulating it prior to the fracture. He heard no sound prior to the fracture. He just woke up and his eye was bleeding. So we have no evidence, expert or otherwise, substantiating the circumstances under which this fracture occurred. Under New Jersey law, you need more than that. Finally, Your Honor, plaintiff argues that even if this weren't, well, implicitly, plaintiff argues that even if this wasn't a complex instrumentality, he may still prove a defect exists based on circumstantial evidence. That's not the case under the circumstances here. First, plaintiffs can only resort to circumstantial evidence when direct evidence is unavailable. That's quoted in the Louder decision as well as Murlack. Here we have direct evidence that it wasn't defective. We have plaintiff's own experts' testimony that it wasn't. Second, even if we didn't have that direct evidence, plaintiff's burden would be to negate all other potential causes of the fracture to show that it must have been defective at the time it left the manufacturer. He doesn't even attempt to do that in his briefing. That's because it can't be done here. Under the facts here show that the bit was purchased approximately a year before the incident. The bit sat in the back of Add-A-Story, the contracting company's pickup truck, for the duration of that time in a PVC pipe. We don't know how it was maintained. We don't know how it was cleaned. We don't know how it was used when plaintiff wasn't on the job, and he was fired and he testified that he was fired and was not at every work site that Add-A-Story worked at throughout the life cycle of this drill bit. And as we discussed with the last point, we have no evidence of of plaintiff's use of the drill bit at the time at the time of the fracture. We don't know how he was tugging on it, whether or not he was awake for a minute but doesn't recall that, or 5 minutes or 10 minutes. All we know is that he showed up ultimately intoxicated on a hot summer morning to go work in an attic. And as he's reversing the drill bit, when it was stuck in the wood, he passes out under those circumstances and wakes up with an injury to his eye. Now, as tragic as those circumstances are, they're not proof of a manufacturing defect. New Jersey does not allow res ipsa locator to prove products liability and product defects here. And under the circumstances here, no evidence supports a manufacturing defect causing this fracture. So it's a lot to digest. I know Your Honor has read the pleadings, the motion practice on that point. So I don't know if Your Honor has any questions before moving on to the warning defect claim.
You can move on to the warning defect.
Defendant's argument on the warning defect claim is relatively straightforward. Plaintiff testified that he would not have worn ever protective eyewear when drilling below his waist. He was drilling below his waist in this circumstance and decided not to wear protective eyewear. Under the circumstances there, he can't prove then that the failure to provide a warning to wear protective eyewear caused his injury. First, there wasn't a warning that said always wear protective eyewear. Second, plaintiff testified that he would have never worn protective eyewear when drilling below his waist, as he was at the time of the injury.
Was that his testimony? Now, and I admit I did not look through his deposition entirely, but the only testimony that I saw referred to was his testimony that it wasn't his practice to do so, and he had never done so. It did not speak to what he would have done under any future circumstance.
Well, under New Jersey law, Your Honor, that's not required. In the case law cited, courts have found that where you can establish a pattern of practice where you are not following the warnings given, then you can't prove, you can't establish causation, proximate causation of the injury.
Right, but then don't you have to establish, in order for that to apply, don't you have to establish that you actually saw the warning and chose not to heed it? Because we've got his testimony here that he never saw the warning in the first place. Well,
I don't think that's the law, Your Honor, and plaintiffs haven't alerted us to any case law that has that holding. It's my understanding that all that's necessary is that you show that plaintiff would not have followed the warnings, regardless of whatever warnings were there. And that assumes that no warning was given. So in cases where no warning at all is given, you may still prove lack of proximate causation based on a showing that plaintiff would not have read those warnings.
But that seems like a hard thing to do on summary judgment.
Well, Your Honor, I think that in this case, the testimony is relatively clear. Plaintiff testified that he has been threading electrical wire since he was in high school. Plaintiff testified that he has never worn protective eyewear while using any drill bit, from the 2-inch drill bits to the 54-inch drill bits. He testified that he's never seen any other construction professional wear protective eyewear when drilling below their waist. And he's testified that he himself had never done that.
Right, but now he's also testified by affidavit that if he had seen this warning and it had been prompted, then he would have changed his practice, his lifetime practice up to now, and would have worn the eyewear. And I can't weigh that credibility determination. That's for, it seems like that's for the jury.
I take your point, Your Honor, but under New Jersey and I believe Georgia law, there is a sham affidavit rule where a self-serving affidavit that contradicts prior unequivocal testimony does not and should not be considered on summary judgment to defeat summary judgment. And here, and especially under the circumstances where it's here, he doesn't explain why he testified the way he did under oath at his deposition, and what change in circumstances prompted his new memory or new belief at his affidavit. The affidavit simply states that had I seen the warning, I would have read it. Well, that contradicts a lifetime's worth from high school through the date of the incident of his practice and his own personal procedure. And under those circumstances, it's not a question of fact under both New Jersey and I believe Georgia law.
All right. I'll let you keep going.
Your Honor, actually on the motion for summary judgment, I believe that concludes defendant's argument.
As to Home Depot.
Oh, I'm sorry about that. Okay, Home Depot. Excuse me, Your Honor. The Home Depot aspect of this case is relatively straightforward. There are no records in Home Depot's possession showing that it ever sold a Southwire drill bit that has the three at issue here at a Home Depot store, a brick and mortar Home Depot store. Plaintiff tries to rebut that by stating, well, our expert was able to purchase one online. Well, that's different than plaintiff's testimony that it was purchased at a Home Depot store. These unequivocal records show that no drill bit, no Southwire drill bit, this brand, this make, this model was ever sold at a Home Depot store. We think that under the circumstances here, that overwhelms plaintiff's self-serving testimony to the contrary. We can explain plaintiff's belief that this was purchased at a Home Depot, but nonetheless, there are no records that exist. And plaintiff did not depose any witnesses from Home Depot, notwithstanding the fact that we discussed that Home Depot's lack of sales of this item at its brick and mortar store since almost the inception of this case. So under those circumstances, Your Honor, Home Depot's unequivocal, unopposed business records should warrant summary judgment here.
All right. All right, Mr.
Good morning, Your
Norman.
Honor. If I may, I'm going to start with the Home Depot argument since it's relatively quick and it's fresh in everyone's memory. If I had $1 for every time a retailer told me that they didn't sell the product that injured or killed my client, I would have a lot of dollars. Mr. Liadis testified unequivocally at his deposition that he was with his boss at a Home Depot store in New Jersey when they purchased this drill bit. That evidence alone is sufficient to survive summary judgment and bring the question to a jury. Notwithstanding the fact that Mr. Marshall, our expert, also purchased the same drill bit online and picked it up in store from Home Depot. Now, if Mr. Liadis's affidavit is a quote sham affidavit, then maybe Home Depot's affidavit saying that they've never sold this product before, maybe that's a sham affidavit too. Now, I don't actually contend that, just as I don't think Mr. Liadis's affidavit is a sham affidavit, but there is plenty of evidence to say and to bring to a jury that this drill bit was purchased at Home Depot. Going to the meatier portions of the motion for summary judgment. I'll start with the argument that plaintiff cannot prove a manufacturing defect. And Your Honor hit on this at the very beginning. Mr. Marshall is not saying that the drill bit is or is not effective. What he did was he performed a number of chemical analyses of the drill bit, compared it to exemplar drill bits, and found that the chemical compositions and physical properties matched. That doesn't speak to defect or no defect. What he really does in this case is he's an accident reconstructionist, a forensic engineer who determined how this drill bit fractured and injured Mr. Liadis at the time of his injury. And he did that through his own fracture analysis. He purchased several exemplars. He had fixed them to, I'm not even sure how to describe it, but he bent them beyond 90 degrees and recorded when they broke. And they all broke beyond 90 degrees. And that's really the crux of plaintiff's manufacturing defect claim here. Under New Jersey law, we don't need to prove the specific defect in a product. New Jersey has adopted the indeterminate defect test, and that's actually in the Murlack case that defendants and we cite in our briefing. And what that says is essentially that all we have to prove is that there was something wrong with this product, whether it's materials or performance, which is what we're claiming in this case, that something went wrong with the product, and that's what caused it to break and injure our client. In this case, we've referenced a design specification document, Exhibit G, that talks about how the drill bit needs to be bent at 90 degrees for approximately 1 minute. And that's under a section called functional testing. That is a functional testing requirement that defendants have imposed on this drill bit so that it performs as expected. Worst case scenario, a person uses this drill bit at 90 degrees, they're not going to get injured. It's supposed to last and work just fine at 90 degrees. Mr. Liadis testified that he would have used it at less than that, less than half of that. He estimates, I think 30 or 45 degrees. Don't cite me on that, but he was using it far less than the 90 degree limit that we're looking at. And the fact that this drill bit fractures at less than what its performance testing requires, that is an indication that a jury can use to say, okay, there is something wrong with this drill bit. And that's why Mr. Liadis got injured that day. And just to briefly comment on Mr. DiBartolo's testimony about the springback aspects of this document, there's no evidence in the record whatsoever, whether through deposition testimony or an affidavit from any of the defendants, about what springback means in this document. All we have is the functional testing requirement that this drill bit needs to last beyond 90 degrees. Moving to the warning aspect of defendant's motion for summary judgment. On the wrong page. Okay, moving to the warning aspect. Defendants are claiming that Mr. Liadis never would have obeyed a warning in the first place, and that he cannot prove causation. And I think Your Honor hit this on the head earlier. Mr. Liadis's testimony was about his habitual use or non-use of safety glasses. That was relating to debris falling from where he was drilling upward. He was afraid of, I think he calls them wood chips that would come down and rain down on his head. And that's when he would use safety glasses. He had no idea that this drill bit might fracture and pierce his eye. If he had known that, I imagine he would have worn the safety glasses that are recommended on by Dr. Wogalter in his affidavit. And when we talk about the warning that is on this particular drill bit, that warning was never given to Mr. Liadis. It was never appreciated by him. He did not assume the risk or intentionally not wear safety glasses. He had no idea that it would be a good idea to wear them under these circumstances. And Dr. Wogalter really goes into the reasoning why a better warning is needed here. The warning in this case, it's on disposable display package. It's not on the front. It's not even on the back. It's in very minuscule writing on the side. Mr. Liadis said he never saw it. His boss threw the packaging away once he bought it. And he's never seen a warning on any other similar type of drill bit. So what we have in the warning context is Mr. Liadis's testimony that if he had known that he needed to wear safety glasses because this drill bit might fracture and pierce his eye out, he would have done so. And that, again, is sufficient to take that issue to the jury. And I think I've rebutted most of Mr. DiBartolo's arguments, but if you have any questions for me, please let me know.
I do not. All right. Mr. DiBartolo, you get the last word, then I'm going to give you a ruling.
Thank you, Your Honor. Just a few points of clarification. First, Mr. Nauman alleges that there's no evidence of the record relating to what the springback test was. Mr. Marshall himself replicated his 180-degree test off of the 90-degree springback test. And there's testimony that I can find and provide to you that shows that he understood himself. So plaintiff's expert understood what this springback test, this quality assurance test, constituted and proved. And that's Mr. Marshall's testimony begins at page 104, line 3 of his deposition. Plaintiffs also misstate the holding in Murlock. They argue that Murlock requires them to show only that something went wrong with the product to prove a defect. That is not the holding in Murlock. Murlock specifically holds that simply because plaintiff is not required to show the product is defective, prove negligence, that does not relieve them of proving that the drill bit was manufactured or designed defectively. And that quote is in our briefing as well. Finally, Your Honor, plaintiff describes Mr. Marshall as an accident reconstructionist. And I know we're going to get into this a little bit later in the Daubert motion. But if that were Mr. Marshall's role, he does not do that under these circumstances. And I can describe his testing in great detail, but very simply, with one test, he bends the drill bit to 180 degrees. Plaintiff's own testimony says it never went on beyond 30 degrees. Why that is considered accident reconstruction is beyond me. The second test that plaintiff argues shows that the drill bit fractures also was tested under circumstances completely unlike what Mr. Liadis testified to. The circumstances in which Mr. Marshall was able to create a fracture in the drill bit involved a drill bit that was not only stuck, not only reversed and placed into the forward position several times, but also torqued so that it broke at the area closest to the end of the drill. Plaintiff's testimony was that he held it straight and he would never have torqued it either way because he believed that would cause injury or break the drill bit. And that testimony is, pardon me, Your Honor. I'll give you the citation, Your Honor, in a moment. But that testimony shows that Mr. Marshall did not reconstruct a relevant accident. He reconstructed some hypothetical accident that has no bearing on this case. And I believe those are the only comments in opposition that I'd like to address. So, Your Honor, unless you have further questions, I'll await your order.
Depot, I don't think the evidence is conclusive one way or the other that Home Depot sold or did not sell the drill bit at issue in this case. I know from both my experience as in hearing cases and my personal experience is that sometimes records, and particularly inventory records and sales records, can be inaccurate. And I also know that folks' memories as to where and when and if they purchased something at a particular place can likewise be inaccurate. I think this is clearly a weight of the evidence question and not a sufficiency of the evidence question. So the motion for summary judgment is denied as to Home Depot. The motion for summary judgment on the defective warning claim, I don't think it's a close question that summary judgment should be denied on that. The main argument is that there cannot be proof of causation because the plaintiff testified he never would have heeded the warnings anyway. And that's just not the testimony, and that's not the record fairly read as I read it. Do I think it's unlikely that he would have heeded the warnings based on the evidence I see here? Yes, I do think it's unlikely. Do I think there could be credibility issues with the affidavit? Yes, I think there could be credibility issues with the affidavit, but all of those are proper subject for weighing of credibility and credibility determinations by the fact finder after the plaintiff is subject to vigorous and searching cross-examination. It's just not a summary judgment issue. So motion for summary judgment is denied on the defective warning claim. I think the manufacturing defect claim is the one that's closest to being disposable on summary judgment, but I still have some lingering issues as to whether ultimately a claim can be presented to the jury at trial. I think Mr. Marshall, the expert, his testimony can be equivocal and can be somewhat not entirely consistent at times. As I read it on the issue, he seems to suggest that there must be something wrong with it because it didn't work according to the specifications. The testing and load specifications from the manufacturer's standpoint, but he also says that he doesn't find or will not testify that there was in fact a manufacturing defect. Ultimately, I think it's got to shake out through the testimony and the cross-examination as to the ultimate outlines of his testimony and what the testimony actually demonstrates at trial in context, subject to full cross-examination. I think this claim may be subject to renewal on a motion for directed verdict or even perhaps for judgment as a matter of law at a different time. But I think there is enough of an issue here as to whether there is enough circumstantial evidence of a manufacturing defect that I should deny motion for summary judgment at this time. So I'm denying the motion for summary judgment as to the manufacturing defect claim. So all that being said, defendant's motion for summary judgment is denied in its entirety. Mr. Nauman, I'll ask you to prepare a proposed order to that effect, present it to Mr. DiBartolo, make sure he approves as to form, then get it to Mr. Townsend and he will get it entered.
Yes, Your Honor.
All right, so that being said, we need to go into the motion to exclude the testimony of Mr. Marshall.
Now, thank you, Your Honor. I don't want to read the tea leaves here, but based on your decision on summary judgment, it seems as though you're going to allow Mr. Marshall to testify.
My intent, unless you want to try to convince me otherwise, is that he should testify and you should vigorously cross-examine him on his methodology and his ultimate conclusions, and argue to me or the jury as to, once that testimony is presented, whether it measures up to present a claim.
Your Honor, at the risk, I prepared for these motions, so it's sometimes a lawyer's desire to just be heard, but at the risk of
it's your right to be heard. So I don't want to discourage you, but you know which way it's going.
Thank you.
So and of course you're entitled to make your record if you want to make an additional record other than that which is in the written record.
Thank you, Your Honor. I think I'll take you up on that. I'd just like to address a few points, largely points that I went over during my summary judgment argument here. But some plaintiffs moved to dismiss Mr. Marshall pursuant to Daubert because he is both unreliable and unlikely to assist the jury. Both those issues really dovetail with the manner in which he tested the drill bit, and the fact that testing does not relate to the underlying circumstances of the fracture, as testified to by plaintiff. As I argued on summary judgment, Mr. Marshall performed two tests. First was a fracture test, and the second was a spring back test. The spring back test involved a 180-degree bend where one end was released and the drill bit, and Mr. Marshall measured how far the drill bit landed. The fracture test, Mr. Marshall attempted to recreate the circumstances under which the fracture occurred. He got the drill bit stuck in a piece of wood. He moved it forward and backwards, and then he went beyond what plaintiff testified occurred and wiggled the drill bit back and forth, creating torque and ultimately causing a fracture. Neither of those tests are grounded in plaintiff's own testimony or the facts of this case. Plus, plaintiff testified that he never bent the drill past 30 degrees. Plaintiff testified that he never wiggled the drill, and he wouldn't have done so because that would cause a dangerous condition. Nevertheless, Mr. Marshall tested the drill bit under these conditions. Specifically as to the 180-degree test, Mr. Marshall testifies that there is an immense amount of force applied to the drill bit when bent at 180 degrees. Yet none of those drill bits that he bent during the spring back test broke. It's unclear how Mr. Marshall's testing in either circumstance show that the product was defective. He found that there was no chemical difference between the drill bit, the incident drill bit, as the exemplars he tested, no mechanical differences between the two. And yet he still found that it was unreasonably dangerous. That's the sum and substance of his conclusion, that the drill bit was unreasonably dangerous under circumstances where it was bent to 180 degrees. Those circumstances have no application here. And for those reasons, Mr. Marshall's opinion should be stricken from the record. Understanding Your Honor's decision on summary judgment, it's defendant's position that if summary judgment isn't appropriate and Mr. Marshall is not excluded at this time, then prior to trial, we should have a 104 hearing to discuss so that he may be cross-examined in front of Your Honor, and we can renew our motions at that time to avoid the risk of confusing the jury, presenting evidence that is irrelevant to the case and likely unhelpful to the issues at hand. So with all that being said, Your Honor, I defer to you and plaintiff's counsel with respect to this motion.
All right. Mr. Bartolo, I think a hearing or a proffer would certainly be something I would strongly consider in this case, given the testimony. I will comment that in some respect, I understand why you would want him excluded, but in some respects, it seems like his testimony, based on your argument and a good cross-examination, could actually be helpful to your case. And I think that's what comes down to me for the helpfulness inquiry, is he is taking some conditions that may be like that maybe fits Mr. Liotta's theory of the case, and some conditions that maybe fits your theory of the case. And then it comes down to the jury's determination. Well, what really happened? Was he really doing this? If the expert testifies that it won't fracture if you're just sitting there applying even pressure at a 30-degree angle, but you have to actually, to get it to fracture, you have to yank it and twist it and turn it and bend it very far back. Maybe that doesn't hurt. Maybe his testimony doesn't necessarily hurt your case. And it's helpful to the jury in deciding, well, what actually caused this drill bit to fracture? And then they have to hear the testimony on both sides and the cross-examination and get the benefit of his perspective in order to ultimately make the factual determination of what actually happened. So I understand there's a strategy and there's pluses and minuses from letting him testify, but there is something in his testimony that I think, maybe not the entirety of it, but there's something in his testimony that I find would be helpful to the jury. So I can't exclude him entirely.
Your Honor, if I could just address that briefly, and at the risk of disclosing more of our trial strategy that you so eloquently outlined in cross-examination, it reverts back to the argument on summary judgment that under New Jersey law, this drill bit and drill creates a system, both individually and taken together, create a complex instrumentality. And that complex instrumentality needs to be explained by an expert. And so Mr. Marshall does not explain the complex instrumentality. In fact, he states that the drill bit and the drill were not defective. So I take your point, but without Mr. Marshall's testimony, they can't get past the summary judgment stage. New Jersey law prohibits this sort of test moving forward without proving that it was a complex instrumentality, without expert testimony where it's found to be a complex instrumentality. And we believe under the circumstances here, the system created and the drill bit on its own are a complex instrumentality. Plaintiff's briefing outlines monotonic overloading, chemical composition, the circumstances of his testing. These all lend to the finding that it's a complex instrumentality, and therefore expert testimony is required. So you can see our thought process there. I know Your Honor is already found on the summary judgment motion, so I will cease my argument and defer to plaintiff here.
Mr. Nauman, anything you want to add?
No, I wouldn't want to steal a win from myself, but what I will say for record purposes is that the only challenge to Mr. Marshall's methodology in the briefing is that it was not subject to peer review. These other Daubert factors that Mr. DiBartolo is speaking of now were not raised in the briefing.
All right, so the motion to exclude testimony of Marshall is denied. And I'll ask you to do the same thing with respect to that order as with the motion denying, with the order denying the motion for summary judgment.
Yes, Your Honor.
All right. There is a motion out there to exclude the testimony of Wogalter. Now, and it sounds like Mr. DiBartolo that you don't think that this motion is moot now. So you want to argue it today?
Your Honor, based on your rulings on summary judgment and your ruling on the defendant's motion to exclude Mr. Marshall's testimony, I believe, again, I'm likely just going to make a record here. But at the risk of being repetitive, plaintiffs moved for summary judgment, motion moved to exclude Mr. Wohlgalter's testimony on the basis that at the time we made the motion, Mr. Wohlgalter was refusing to testify at his deposition. So we had no idea what the basis of his opinions were, the testing he performed, the standards he applied, etc. Since making that motion, Mr. Wohlgalter did testify. And it clarified and submitted an affidavit and clarified or attempted to clarify his views on this case. Defendants have several, take issue with several aspects of Mr. Wohlgalter's testimony that have not been briefed because of the procedural posture and that he ultimately testified after we made the motion. I'm not sure how Your Honor would like us to proceed in that context, whether this is another instance where we can make a motion closer to trial and perhaps a 104 hearing is appropriate, or I can make the record right now of the basis of our belief that Mr. Wohlgalter should be excluded briefly, and you can make your determination.
I'll let you raise it as a motion in limine, and we can handle it at a pretrial conference.
Thank you, Your Honor. That seems appropriate under the circumstances.
All right. So that one I'm going to defer. All right. I think that takes care of defendants' motions.
And Your Honor, I apologize for interrupting. Would you like the order on the Dr. Wohlgalter motion to say deferred or denied without prejudice?
I'm going to deny without prejudice. It's denied on the basis it was made, but we leave open the door to bring in other grounds to exclude him.
Understood.
All right. All right, Mr. Nauman, you've got motions for partial summary judgment.
And I believe that's the only outstanding motion. It looks like we ran the gauntlet and got through everything.
Yes.
And I'll be brief and state that plaintiff is resting on his briefing. The Souter case and the strong public policy in New Jersey is that workers should not be held responsible for injuries they suffer from a defective product on the job site. After reading defendant's briefing, my understanding is that their position is that there has to be an employer-employee relationship. I'm not seeing that distinction in the case law. I think the case law is very clear that it's not an employer-employee relationship that's important. It's that the injury occurs on a job site or at a workplace, because that is a circumstance where the injured party has no meaningful choice but to engage in their work as a means of earning income. So I think that's the palpable distinction in the case law that is overlooked by defense counsel in their briefing. And as we state in our briefing, contributory negligence and assumption of the risk have been absorbed within this umbrella of comparative negligence in New Jersey. And comparative negligence itself, because of the Souter decision and over 40 years of case law since then, a very strong public policy has emerged in New Jersey to protect workers who are injured at job sites.
All right. Thank you, Mr. Nauman. Mr. DiBartolo.
Thank you, Your Honor. Plaintiff accurately states that Souter has been in effect for 40 years, yet cites no case law applying Souter outside of the employee-employer context, and cites no case law on the flip side applying it to an independent contractor. Plaintiff accurately cites that the policy rationale behind it is because employees have limited control over the tasks they perform and the manner in which they perform them. Independent contractors, as set forth in our briefing, have much more leeway in the manner in which they perform their duties. Here, both plaintiff's testimony and the facts underlying his employment status show that he was an independent contractor. He testified he was an independent contractor, that he was laid off at the time, that he was working on a sporadic basis. He didn't pay any taxes, was paid under the table, pursuant on a job-by-job basis, sometimes hourly, sometimes not. And so under these circumstances, there are no New Jersey cases limiting this limited but extreme carve-out to the Product Liability Act. And therefore, this should be denied on, the plaintiff's motion should be denied on that basis. Further, the motion's premature. None of the cases cited by plaintiff, and we have found no cases that apply this pre-trial or after a finding that a defect actually was present in the product. In fact, all of the case law says that after showing that the failure was due to a defect, only then is comparative negligence, the waiver of comparative negligence considered. And then finally, the manner in which plaintiff was contributory negligent in this case is distinguishable from the suitor line of cases. All of the cases cited by plaintiff and from what we understand from our research deal with the plaintiff's use of the allegedly defective product. Here, plaintiff showed up to work intoxicated and determined not to wear safety equipment. Under plaintiff's reading of this carve out, we could all show up to work drunk and never be held contributory negligent where their product defect is allegedly involved. That is an absurd result and does not align with suitor and its progeny. So for those reasons, defendants argue that the court should deny plaintiff's motion for partial summary judgment.
I know that you mentioned that it's premature. What is the harm in making a ruling on this issue now, as opposed to after some finding, at least some potential finding of liability at trial? Don't the parties want to have some semblance of expectation as to what the total universe of liability would be?
I think, Your Honor, that the parties have a general idea, we are able to factor in the danger of this argument being accepted after a defect is found at this time and factor that into their trial preparation. The fact remains is no court that the defendants are aware of, and presumably plaintiffs, have made this finding until after the fact finder, whether the jury or judge, found that it was due to a defect. And in reading some of the case law, it suggests that that's because evidence of plaintiff's negligence, whether or not contributory negligence is a defense, contributory fault is a defense, is relevant to causation. Plaintiff can be found wholly the cause of his own injuries, and in that instance, all of this evidence comes in as well. But to relieve the jury confusion, I think that's why the court defers until after trial, where it can give a clear, succinct jury instruction as to the purpose of that evidence after the ruling has been made. If it's done before trial, the court is constantly in the position where it needs to give a curing instruction as to the purpose of that testimony. And we are facing objection after objection whenever that line of questioning is brought up. So it creates a much more streamlined process to have the jury find that a defect is in fact in existence, to avoid those confusing issues and potentially, I don't want to say frivolous, but unfounded objections during trial.
So your position is that regardless of whether comparative negligence cannot be considered in the damages part, it can be considered in the liability part? Clarify this for me.
Plaintiff's comparative fault is also necessarily evidence that he was the sole cause. So comparative fault is what percentage is plaintiff's fault. Plaintiff also, okay, setting that aside, plaintiff still needs to show that he himself and not the product or a product defect was not the cause of his own injuries. Evidence of that would be the type that is going to be admissible here. The fact that he showed up to work having drank, the fact that he decided not to wear his protective eyewear. Those each could be the sole cause of his injuries. So whether or not they deal with contributory negligence or causation as a whole, that evidence is relevant and admissible. And the cases we cite in our briefing, we don't make this argument because it, in our opinion, is premature. But the cases cited in our briefing state that the evidence that would be admissible to prove causation is necessarily overlaps with evidence of contributory fault.
All right, Mr. Nauman, your response.
I think there is something to be said about the narrowing of issues that granting plaintiff's motion for summary judgment might afford. Mr. DiBartolo's concern is that defendants could prove that plaintiff is the sole cause of his injury. And if that's the case, there's no defect. There's no manufacturing defect, there's no warning defect, there's no defect whatsoever. So granting plaintiff's motion for summary judgment, disallowing evidence and argument and apportionment of damages based on comparative negligence, that doesn't detract from their ability to prove their alleged defense that this drill bit was never defective in the first place. They're going to have their own experts, their own company witnesses who are going to talk about the drill bit and explain how it was made perfectly, and that the only way this could have happened was Mr. Liadis is somehow at fault. And it's not a defect. So that's where I see the benefit of granting plaintiff's motion for summary judgment at this stage.
So the jury hears all the evidence as to what he supposedly did that made it his fault, that the drill bit fractured and that he caused his own injuries. And under sort of your interpretation, then if I were to grant your motion, if the jury finds ultimately that there was a defective design or defective warning, then his not defective design, defective manufacture or defective warning, then whatever negligence he may have exhibited on that day, the jury cannot take into account in their determination of damages.
Right.
This one I'm going to, frankly, I'm going to have to think about some more, because one thing is clear to me is that in the first place, this complete carve out, judicial carve out on claims when an employee is using the employer's equipment is a carve out that just would never happen in Georgia under the cases from our Georgia Court of Appeals and the Supreme Court. This type of exception just wouldn't stand here in Georgia. So I'm in the position of trying to interpret how New Jersey law would come out on an issue that appears not to have been addressed squarely by any appellate decision, one way or the other, based on New Jersey's public policy and how the New Jersey courts would come out with it when they are using a different judicial philosophy than we use in Georgia. That's not an easy task, and it's not a task I take lightly, because how I come out on this, I think, makes a fairly substantial difference in the potential recovery. It appears that we've already got evidence, some evidence in the record, and which I think defense is going to rely on in good part about the condition that the plaintiff was in on the day of the accident and what things he did or did not do to be safe. So I'm going to have to reserve ruling on that, and it may make sense to deal with it closer to or at trial, but I'm not prepared to decide that issue today, and I think I want to take a deeper look into New Jersey law on this before I do, because it appears to be a case of at least first impression at the appellate level. I don't see a reported case. Mr. Bartolo, you said there's none that apply it outside the employee context, and then there's none that's saying that it doesn't apply to an independent contractor. So I really don't know what the answer should be. And then who do you appeal it to? Do you appeal it to the New Jersey? Do you appeal it to the New Jersey Court of Appeals or the Supreme Court to decide the issue under New Jersey law? But does the Supreme Court of Georgia get to decide ultimately what New Jersey law is? This is interesting and new ground for me.
It's an interesting position, this particular issue. Absolutely.
Your Honor, I've been pretty quiet today, but if you don't mind, I'd like to make just one quick point about this decision that seems to be weighing on your mind. It appears to me as a Georgia lawyer reading New Jersey law and what Mr. De Bartolo has said today, and we represented in our briefs, and you seem to agree, is that the exception to the comparative negligence in the employer-employee context does not necessarily apply here, because we are dealing with an independent contractor. And so if you were to rule that this exception should apply in this case, it would be an expansion of New Jersey law. And so if you're asking yourself whether or not that is something that is warranted under these circumstances, right, you look back to the public policy underlying the rule, which I think Mr. Naumann clearly stated during his argument. The public policy is that employees do not have any control over the instrumentalities that they are given to use at work, which is not the case here with this independent contractor who testified at his deposition that he brings his own equipment, his own safety gear, all that kind of stuff. So that's my one contribution for today.
And I take that and I acknowledge that, but he didn't provide his own equipment in this case. That's and I think the Souter case talks about the fact that you're not choosing your own equipment, and it speaks in terms of, well, you have a choice to either use it or not the job. And I'm not sure that he had that choice here. I'm not sure that he didn't have that choice here. In fact, I think it seems to me the more that we talk about it, the more it might be more suitable for rediscussion after hearing the evidence.
Understood. Your Honor, would you like a separate order reserving ruling or just hold on to the motion as it is?
Let's just hold on to the motion as it is, and I'll be waiting for someone, particularly you, to renew that motion.
I will, I promise.
All right.
Council Philip, could I please have your first or last name? I just see Philip.
Sure. My first name is Philip. Last name is Henderson. Henderson.
Thank you.
Ms. Winfrey, my name is
And
Stephen.
Your Honor, my apologies today. I pulled into the office, grabbed my bag out of the back seat of my car, and realized my jacket was still hanging on the table or the chair at the kitchen table. So my apologies for my half casual appearance today.
I think a shirt and tie is perfectly appropriate on Zoom.
All right, good to know.
Thank you. And Mr. Stephen Norman, I have your name here.
Okay, thank you.
All right. Thank you.
All right, thank you. This was definitely an interesting, a lot of interesting issues. I want to thank council also for actually being brief in your briefs. We had a lot of complicated issues, but I never felt like in reading any of your briefs on either side that you were overdoing it or being overly repetitive. I thought they were concise. The arguments were squarely presented and well presented, which made it a lot easier for me to get through them and for us to get through our argument fairly quickly here today. So thank you on both sides for that. Any further business before I let you go?
Not from plaintiff, Your Honor. Thank you.
I don't believe so, Your Honor. Thank you for your time this morning. That was a lot. I appreciate you taking those motions all at once.
All right. Thank you, everybody. Everybody is excused. Thank you, Ms. Winfrey. Ms. Winfrey,
Have a good
am
one.
I going to have you next week?
Judge, I think you better ask. You better put in your request now. I will be there tomorrow and we can talk about it some more.
Okay.
Okay, thank you. See you tomorrow.
Trinity, tell them I want Octavia for next week.
Judge, is it all week case? 5 days?
I expect it to be 5 days. It's a malpractice case. It's a bench trial and it's going to be difficult.
Oh, okay. I will. Trinity, you'll have to ask every time I do. We'll talk tomorrow.
Okay.
I'll see you guys tomorrow.
All right. Thank you, everybody.
Take care.
You're welcome. Bye-bye.
Take care. Good luck next week, Your Honor.